All right, so getting into agency a little bit more, okay? Agency, yes, question.
Can I ask a question? Okay, so I have something going on like that, property disclosure. The person that owned it didn't disclose it for a lawsuit beginning to happen with the condo community.
Okay.
We know they know because they did a gag order to the head of the condo association, who's also a realtor.
So the question here is, what happens when a disclosure form does not contain a pending lawsuit?
It's not pending yet, but they knew it was coming.
Okay.
Because they did a law, the guy's attorney did a lawsuit to the HOA condo president, who's also a realtor, told him he wasn't allowed to disclose anything. So we know this all happened, that's coming out. How quickly, how soon do we have to do a litigation from that, from the time of closing?
So your question is,
so we haven't pursued it yet?
so basically they didn't disclose that there was a pending lawsuit, but I'm sorry, a possible lawsuit. Nothing has been filed, but there were grumblings and rumblings that they probably were going to. The condo association was likely going to sue.
Gave them a gag order so they couldn't say anything to this.
Who gave a gag? Like, what do you mean? Who did?
The owner.
Of the property?
His attorney.
Yeah.
Gave a gag order to the condo association president, who's on the board.
Okay.
Who knew all about it.
So the condo association.
Anything on condo docs or anything.
So the condo association was going to sue someone, or the condo association was about to be sued?
They actually sent him a lawsuit too, to not say anything about this.
Okay, I'm not following your who's who. So I just want to make sure I understand this so I can explain it to everybody. So there's the attorney is an owner of a condo in the development, but who is going to sue who in the actual lawsuit?
The condo association is going to sue the builder and all.
Okay, so the condo association is going to sue the builder for faulty construction, right?
Also put a lawsuit on him to keep a gag order. So
the owner filed a lawsuit against the condo association trying to say, hey, I want an injunction for you not to disclose this information because it will diminish property values.
Yes.
Okay.
But come to find this all out.
Okay.
Afterwards.
So your question is, would a buyer have a remedy against a seller for fraudulent non-disclosure in the form? I've never been asked that question. And I'm thinking about it as I'm understanding the facts. And, you know, I know that generally speaking, lawyers are advised never to give answers in a class setting like this. So let me pose this more as a hypothetical sort of if answer. And my thought is this, is that I would want to go back and read the statute and read and research cases and all of that. But without doing that research, my off-the-cuff understanding is that that lawsuit that the owner filed against the condo association is public record. So now knowledge is imputed on everybody because it is a public record, and therefore it is not a latent defect. And that's really what the issue is knowledge that a lawsuit might be filed considered a latent defect? I would sure hope not, because there's no way to know what the outcome of that lawsuit would even be.
You wouldn't allow them to even talk about the problem.
I still don't know that would be a cause of action for a buyer. I mean, anything can be litigated, and yes, that's probably something that would have to be to get it, resolved one way or the other, because settling lawsuits is sometimes cheaper than winning them. So it's quite possible that you would want to sue, but I would just say that without doing more research, I can't say for certain, but I sure hope that based on what I know, that there would not be a cause of action for that, because the property disclosure form, I don't believe, has a section talking about pending lawsuits or potential, Yeah, but the real question of what the form is designed for, and I would argue purpose and intent of the form, is physical defects. And that is the possibility of a monetary problem later for owners in the association, which I don't even know is within the scope of the disclosure form of itself.
Actually, I know what kind of association you're talking about, because I'm in contract. My buyer's in contract with the builder right now. So we went into contract in November. The litigation was filed December 22nd. So obviously there was nothing on the condo association, anything, for when we went into contract. But because it's pending litigation, it's not a defect on title until there's an action.
Until there's a judgment, correct. Correct. So it's not a title defect, and I'm saying I don't believe that it would be considered and defined as a latent defect, but somebody could probably get creative and find another reason
Obviously, he
to
didn't,
stand on as far as filing a complaint.
he put an injunction on,
Plus the fact that this pending lawsuit could be considered a matter of public record.
Right. The one of the owner against the condo association for the gag order is some knowledge that would be imputed upon the buyer. It's the same thing for like death in a property or something like that as far as disclosure goes, is that, you know, as a legal rule of thumb, you probably don't have to disclose that. But as the OAR points out in their white paper on, you know, disclosing suicides and things like that, is they're going to find out, because it's probably public record somewhere, you might as well tell them. You know what I mean? And so that's generally what it is. You don't want to end up in a lawsuit. You don't want your clients to end up in that. But if your client says, I do not want to disclose that there was this death in the property or whatever, do you have a problem if they go that route? I mean, certainly consult with a lawyer for that and consult with your broker and everything, get approval on that sort of thing. But I would say a lot of times that's a risk that is the, you know, consumers to take, because that is not something that is clearly a defect in the property. There is no case that I know of that says it's a defect. It's just the likelihood that somebody will get mad that you didn't disclose it, and then maybe they'll sue, as in this case, that they're threatening lawsuits against, you know, the seller. And so perhaps disclosure would have been a good idea, but it's not necessarily legally required.
the seller put an injunction so they wouldn't talk about it.
Right.
You don't think that they're trying to hide something?
Well, they may be, but that doesn't mean that it's a latent defect that is required to be disclosed.
So, for instance, if we do go try to sue them, how much time do we have to do that?
Statute of limitations is typically 1 year on matters. And I'm not a litigator, so I cannot tell you if there's a specific exemption, like breach of contract claims and different things like that. I mean, usually that's what we're talking about, but other things have a much longer statute of limitations, and I am not an expert in the rules of civil procedure, so I can't really answer that with any certainty.
The moral of that story is don't ever lease, buy, or sell to an attorney.
Question in the back?
So, do you have to disclose that somebody had passed away in the house?
No, that's what I was saying. You don't have to disclose that somebody passed away in the house. But as the OAR recommends, if you go to their website, they have a paper on that. They more or less say that it might be a good idea to disclose it because people will find out anyway.
Even if it was like an elderly person?
Yeah, again, you don't have to. I mean, I'm just saying you don't want to make that determination for your client. You don't want to practice law and tell them what to disclose and not disclose. So keep that as a rule of thumb. They're probably going to ask you. It's not your place to tell them. I'm just kind of letting you know these are my opinions, and so you might be able to say, hey, look, I'm not a lawyer. You need to consult with one, but I've never heard of a requirement that makes you do that. You know what I mean?
We went to a house and it looked like we didn't have and he said, don't they have to disclose that as something?
No, just ordinary deaths, I don't believe, are even stigmatized properties in general, and that's really where it gets gray, is stigmatized, like a murder or a suicide or something along those lines. That's when it gets grayer, and that's where the OAR has recommended to realtors, suggest to your client that they should, because you might get pulled into litigation otherwise, because a buyer could ultimately find out about it from the neighbor and then be super pissed and want to file a lawsuit. And they may not win, but you got to spend a lot of money defending that. So, again, it's about risk. So, okay, so you're in an agency relationship with a consumer, and you're in an agency relationship with your broker. And so there are various duties associated with that. You are an agent for two purposes, and you have two principals, right? Your client is your principal, and your broker is your principal when you're an agent. So you have this triangular relationship where the consumer obviously has a fiduciary relationship with you and with the broker. Okay, so that's why when you have two agents in the same brokerage, you've got a dual agency situation, because you're actually just an agent for your broker. So how do you establish liability when it comes to agents and authority? It can be broken down into these concepts, okay? There is actual authority, which has sort of this consensual authority concept given to the agent by the principal, okay? So signing a listing agreement is the actual authority that you have to go list their house. And within it is express authority, okay? This is very common sense. You're specifically said, I can do this. It's in the written contract. That's express authority. But then there's implied authority, right? So the agent is impliedly authorized to do everything reasonably necessary to carry out the principal's expressed orders. And so if there's anything that is not reasonably necessary to do that, you may be acting outside the scope of your actual authority, thus giving rise to liability on you, okay, to the principal. So apparent authority is when the general public thinks that you have authority, all right? So where the principal's words or conduct would lead a reasonable person in a third-party position to believe that the agent was authorized to act. And so the intersection of actual authority and apparent authority is how you get this sort of chain of liability that passes between the agent and the principal. So the long and the short of it is, you've got to be worried about your liability of the agent to the principal. And so if you acted, in this middle one, if you acted without actual authority, okay, but the principal is liable to the third party because you had apparent authority to them, you are going to be liable in court, right? You're going to have to pay that loss because you acted outside the scope of what they authorized you to do. So this is why you want a listing agreement. You want the actual duties spelled out, so there's not this gray area of actual authority. And so I recommend, obviously, you talk to your brokers about it if you aren't already, but you should have a buyer's representation agreement too. Under the law, it's the same thing. So you still have the same risks. You might as well have a buyer's representation agreement. And I talked around the state, and it seems like, maybe about a tenth, of agents use that. Some brokerages require it, others do not. They don't worry about it. But really, when I look at it, it kind of has the same risks inherent in it as far as your duties. And if you spell them out, you're much less likely to have a potential lawsuit related to you acting outside the scope of your actual authority. Okay, so I already kind of mentioned this. It's illegal for a licensee, a salesperson, an agent, to directly represent any consumer without a broker involved. It always has to be that triangular relationship because that's, in Ohio, what is required. A broker's license is required, and the broker gets the commission, and the agent is basically a licensee of the broker, and that's why everything's always paid to the brokerage and that sort of thing. Okay, so I mentioned that Ohio law allows for two agents from the same office to represent two different people in the same transaction, and the broker is the only person acting as a dual agent, right? So you have the broker that has connection lines drawn to both buyer and seller, and then the buyer's agent and the seller's agent have lines drawn to buyer and seller independently, but also lines drawn back up to the broker. So there's a lot of connections, but the agents are still somewhat separate, even though the broker has this dual agency role, because knowledge can be imputed from the agent to the broker, thus giving rise to some potential liability, as you'll see in some of these cases. So I'm going to kind of skip through, talk about responsibilities. You have a duty as an agent, fiduciary duties, right? You've heard fiduciary. What it means. You have the duty of accountability, which means you need to make sure that any money you receive is given to the broker and held in trust for the benefit of the client. You must maintain reasonable care and skill, okay? You have a duty of care. So by definition, negligence occurs when the agent unintentionally breaches the duty if you fall below the standard of care. That is why you are here today getting your core law credits. Because if you don't maintain your licensure and you don't maintain education, you're going to be found to be liable for negligence in your duties as a real estate agent. And so the same thing would go is if you're a residential agent and you've got some friend who all of a sudden has a commercial deal for you and you take it on, well, you might have a problem because you don't have the reasonable care and reasonable skill in dealing with commercial transactions. Potentially, you could be liable to your client for negligence. If you messed up and they said, what were you doing? So you got to be careful with that sort of thing. You got to maintain your education on it.
Jonathan?
Yeah.
Isn't there talk of splitting the two licenses, making it into two?
I have heard of that, yes. I don't know the details of when that will happen, but I have heard about the fact that there's a little bit of momentum behind making a residential license and a commercial license and separating them all entirely. So, does anyone here know any more details about the progress of that? No? Okay. All right, you have a duty of obedience. All right, you must follow the directions of the principal and not step outside the scope of the agency relationship. You have a duty of loyalty to keep information that should be kept private. And you need to make sure you put their interests above your own. And you have a general duty to avoid conflicts of interest. Also, you have a duty to disclose material facts that relate to the transaction to your client that they would want to know. And then later, you have a duty to also disclose latent defects. We were kind of talking about that a little bit. I'll get into it here again. I'm going to skip through this because we're running a little short on time. Dual agent. Let's make sure we hit on both clients honestly. You have a duty to not disclose information that is confidential or that would have an adverse effect on one party's position unless you are otherwise required to by law. And you shall not advocate on behalf of either party. If you're a dual agent, you can't really advocate for either side. You just kind of have to be this neutral middle person. And so that can get you in trouble if you don't act that way. You shall not recommend specific terms, including price. You shall not disclose a price that a buyer is willing to pay or that a seller is willing to accept. So you can get yourself in some hot water when you're like, well, I know they'll take this, and you're kind of like trying to bring them together. You need to stay out of that and let them decide what the price is going to be, what they're willing to pay. Otherwise, you might have some liability. All right. I've already kind of said that. Let's take a look at this first case. Black V Stouffer. So this is where the Blacks were the buyers. They were buying a condo from Martha, the seller, and Stouffer Realty was the broker. Black signed a dual agency agreement with Relic, the salesperson agent. So the agent, who was an agent of Stouffer, was representing both Martha and the Blacks. There's a lot of facts, and we don't have time to get into all of them, but basically, there was an initial offer. The very first one was a $500,000 offer with a home sale contingency. So things went on, and somehow it came out that it was declined and countered at $515,000 with a home sale contingency. And eventually, the parties all alleged in court that the realtor Relic didn't really convey these transactions. It was all verbal. It was all talked about. They weren't formalized into writing, and eventually, Relic agreed to give up $5,000 of commission, and the parties agreed to a $510,000 sales price with a $150,000 earnest money deposit and 5 days to apply for financing, or the contract could be declared void by the seller. The Blacks did not apply for financing within the 5 days, did not provide the evidence they were required to, and therefore Martha could void the contract. And she did not, so therefore they were bound. And ultimately, the appraisal came back in low, and the Blacks could not get financing. So Martha eventually sold to another party for $487,500, so much less than the $510,000 that was initially contracted for. So Martha sued the Blacks for the breach of contract. Martha sued Relic and Stouffer for breach of fiduciary duties. And they also alleged fraud. Like I said, you got to throw in everything, throw in the kitchen sink. When a lawsuit gets filed, the attorneys will find anything they can in the alternative to find someone liable. So what happened is that the Blacks won the case, and that Relic and Stouffer had to pay $26,000 in damages. And what was interesting is upon appeal, the jury award of attorney's fees of $10,000 was overturned. But the long and the short of it is the agent, and the broker were both liable, for $26,000 plus. And why was that, right? Well, based on the opinion of the court, I sort of extrapolated three major principles here. One is that Relic, violated terms of Ohio's dual agency disclosure. And that is that the agent shall prepare and present all offers and counteroffers at the direction of the parties. She didn't put them all in writing. Apparently there was a lot of verbal negotiation. Number two, the agent shall not advocate or negotiate on behalf of either the buyer or the seller. And the parties felt that she was advocating against them. Each one of them had testified that they didn't feel like the agent was representing them, that she was constantly sort of taking the devil's advocate position or whatever. So Number 3, the agent shall not engage in conduct that is contrary to the instructions of either party and may not act in a biased manner on behalf of one party. Both people actually thought she was biased on the other party's behalf, so that was kind of ironic. And basically
So she did her job.
Pardon me?
So she did her job.
No, actually she was not, she was acting biased against her client.
Both people thought she was acting biased against them,
No.
then
Doesn't work that way. No, she didn't. She didn't do her job. The job is not designed to be acting against your client, where when the client says, "I'd like you to do this," and you don't do that, or you say, "That's not going to fly. We shouldn't. I'm not going to do that," and sort of.
that's not being, biased on the other person's part. It would be like, they say, do you think she'll take this amount? And the person says, no, I can't tell you that.
Yeah, there's nothing wrong with saying that. That's not what we're talking about.
Probably what they're saying, because that's probably
No.
what they felt she was more.
No, she was liable because she was a bad agent, and the testimony bears that out. You know what I mean? And so the point is that both sides thought that she wasn't doing a job and they were displeased, which is why it ultimately ended up in a lawsuit in the first place. And so that the agent wasn't, returning phone calls, wasn't communicating, didn't clarify what her duties were as a dual agent. And so, well, I didn't have time to type it all out for you. Yeah. So, I mean, we're talking about a 50-page case here. I mean, you know what I mean? So, anyway, the lack of trust and bad communication by the agent, as well as poor contract preparation, were the key sins here, okay? And just so you know, this agent had to pay $26,000 for that. So you guys have risk. This case is an example. If you ever got, a lawsuit against you for breach of fiduciary duty, the plaintiff's attorney is going to pull this case up, number one. You know what I mean? They're going to say, based on this case, you need to decide the exact same way in this case, the agent is liable. So that's what I'm saying, is you have to be very careful. Every case is dependent on the details of the facts. My point is the court said that the agent did not satisfy these 3 mantras of the Ohio dual agency disclosure. So keep that in mind. Okay. Moving on to caveat emptor and disclosure. We started talking about disclosure a little bit earlier, about latent defects. Caveat emptor means let the buyer beware, okay? And the buyer is expected to carefully examine the property and not rely on the seller or the seller's agent to point out problems. That's what it means, right? So latent defects are hidden defects. Patent defects are visible defects, and a seller's agent, a listing agent, must disclose latent defects that they know about, okay? But there is no legal obligation on the part of the seller or the agent to disclose patent defects. There is an obligation based on the disclosure form to disclose some patent defects that are being asked about. But otherwise, if there is a blatant problem that is open and visible, a court will not impose an additional duty on them to disclose it. Okay? The issue is latent defects. So, Allison v. Cook. This was a Warren County case back in 2000 that originated when the facts all started around 1994. And so, they had this land on a lake, and the southwest corner, okay, started, falling into the lake. Basically, it was a sort of a little bit of a hilly area, and it was kind of falling into the lake. There was land slippage. And so the Army Corps of Engineers had the neighboring land, and they all looked into it, and that somehow the mayor got involved, and they all said the land was safe, okay? Well, in 1996, it got a lot worse. There was heavy rains, the lake rose, and then all of a sudden, things started happening. The sidewalk on the property cracked. It moved away from the house. The southwest corner fell and created a large ravine. And part of the patio and sidewalk fell into the ravine. Much of the ground had washed away, and it exposed a fuel tank, okay, used for a furnace. So the property owner called the mayor, and the mayor had the fire department declare the house unstable and ordered the owner to move out, to empty the tank, and to remove the fuel tank from the property due to the danger it posed. They surrounded the property with yellow tape, okay, and signs. So an insurance adjuster came out and all that, and there was testimony about what the insurance adjuster did, and they told Cook that the property damage was caused by the adjacent Army Corps of Engineers land falling into the lake. So after May of '96, a couple months later, the slippage stabilized, and there was a 20-foot drop behind the shed, and part of that property is now a ravine. So the property owner had an inspector come out, and then the city declared the property was now safe, the land slippage is stabilized, and she could move back in.
You sure this wasn't Buckeye Lake?
Good question. Up in Warren County. I didn't get the name of the lake on this case when I read it a couple years back. Anyway, the Cook could move back in, but did not. In January of '97, Cook hired Kaufman. Okay, Kaufman's the realtor, to sell the property. So Kaufman's you. And they filled out a real property disclosure form. And in April, Allison is the buyer. Allison saw the listing and called for an appointment. Kaufman had Allison sign a dual agency disclosure form. So Allison went to the property alone because Kaufman said he was busy, and so Allison did his own inspection without the realtor present, but they ended up making an offer, and they made an offer without the real property disclosure form. So the buyer never saw the real property disclosure form, but then they later went back to the property a couple times and walked the property, and so even though initially he didn't see the real property disclosure form, he made an offer, and he had seen the property by himself. And then after that, after they were in contract, he saw it more. So Kaufman told Allison, realtor told buyer, that fire department told Cook to move out when the southwest corner collapsed, but that they told her that she could move back in because they incorrectly thought the house was settling. She said Cook didn't return because she found housing closer to work. So this was all testimony at trial. After Cook, seller, accepted the offer, a second property disclosure form was given to Allison that said the fuel tank was empty and flooding, drainage, settling, and grading problems were visible along the south and southwest walls of the house. Nothing more about this history that I just gave you. All that came up at trial. Allison had the house appraised and inspected. Kaufman was present, the realtor was there, and told the inspector that the damage to the southwest corner was due solely to excessive rain and drainage from the gutters. The inspector concluded that they just needed a retaining wall, and that would secure the area, and that they could get the loan and everything could move forward. So they made an addendum based on that, they got an estimate, and they moved forward. They closed the sale. The contract said the sale was as is, and in total at trial, it was determined that Allison, the buyer, saw the property 5 times. Later that year, after the sale, the western edge began collapsing, and the fire department showed up again, asking Allison, the new buyer, if they had removed the fuel tank. Trees began to fall, more erosion happened, it worsened, and Allison told the realtor that he felt he was misled. The realtor said she would look into it, but if he wanted to sell the property, she would list the property for him. so that's nice of her. And that basically Allison, the buyer, new owner, now refused. He said, no, I don't want to list the property. So after 13 months of being there, he felt that it was unsafe. He moved out, feared for his safety, and hired a lawyer. Allison then sued the realtor and the seller, seeking rescission, compensatory punitive damages, and attorney's fees. So what do you guys think happened?
I think Allison won.
You think Allison won? Okay, so the buyer prevailed. What do you think happened to the realtor? Yes?
I kind of think that because he had the inspector, he had notice of the defects in the property, and relied on the inspector's opinion. So the seller didn't deceive him.
Okay.
Now, the dual agency thing bothers me a lot.
Yeah.
Why a realtor with a property like that would ever enter into beyond me, because that shows an extreme line of
Yeah, great comment. Yeah, the fact that the realtor even was a dual agent on a property with some known defects, that certainly is a risky situation. But yeah, some people think yes. I mean, obviously it makes sense. Common sense might say, you know what, that's unfair to the buyer. They didn't get the whole story. They should have. Yeah.
But didn't the agent disclose the whole time that the west wall, the fire department, the tank?
Yeah, the thing about the facts were that there was, disclosure, but just like in the real world, it was never complete. You know what I mean? It was like things were said, but was that true? What was really said? One person says that A was said, and the other person said, no, it was really B that was said. So there was a lot of that going on.
They had the property disclosure when we signed.
Yeah,
Actually.
which didn't fully state the history either. So some question about the completeness and accuracy of that. Yeah.
Where, if this is involved in a mortgage, where would the lender be in a uninhabitable house.
Oh, we'd be drinking.
Yes, that's exactly where they'd be.
Would they be involved in a lawsuit
They'd
somehow?
be packaging it.
Yeah, in this type of lawsuit, no, because the mortgage lender doesn't really have anything to do with the suit. The lender didn't do anything wrong. They provided a loan, and sure, a buyer could include a lender to say somehow you should have given me a mortgage loan if you knew this, but the lender would have no knowledge.
How is he
So.
going to get out of a loan on a house he can't live in?
Well, that's part of why he's suing for damages. So exactly. So the trial court found that Allison saw the yellow ribbons, okay, that Allison inspected the property, and that Allison received the property disclosure form. They found that caveat emptor governs real estate transactions, and that the collapse of the southwest corner was visible, and therefore it was not a latent defect. They found that the answers on the real property disclosure form might have been incomplete, but not fraudulent, because he didn't see it until after closing. So the trial court found for the sellers and the realtor, and the buyer lost. So obviously the buyer appealed. And the appellate court said, what? What do you think happened on appeal? Allison won on appeal. Why? They felt sorry for her. True, probably, yes.
I have a question.
Question, yes.
Whoever said the house was okay to go back into when Cook owned it, where's their liability on this?
Goes to government.
Basically, there is no uniform set of liability for somebody who says, yeah, this house, we are no longer declaring it sort of a hazard, and so you can't, if it becomes a hazard and he doesn't feel safe, there isn't a way for you to then go after the city for that. There's no cause of action for that.
What about the Army Corps of Engineers?
Yeah, again, they were the neighbors, and they were trying to say certain things, and their whole role in this was based on whether or not their land slippage caused the other land slippage, which had to do more with what the realtor was alleging. And so basically it was saying that even the facts that were being given were being testified differently. Different people remember different things. It really ultimately is an insignificant part of the case. But basically, I'll just cut to the chase here. What happened on appeal, as you much all agree, should happen, Allison prevailed. And what the way this works, though, is that Allison prevailed on the appeal. And an appeal is not to retry the case. An appeal is to say that the court misapplied the law. Okay, remember, a jury is a finder of fact. And you usually cannot appeal a finding of fact. You can only appeal the assignments of error that were made in the trial or by the judge's application of the law. And so that's what was going on at the appellate level. So an appellate court either upholds the assignments of error that an appellate makes and sends it back to trial court to be retried, or they deny the appeal and say, tough cookies, you're stuck with it. So here they said, yes, we're vacating the judgment against you because the trial court screwed up, and you got to go back to court and have this tried again. And of course, as what often happens when an appellate court does this, they list out all the errors that were made by the court. And in that, they kind of go, hint, hint, trial court, you should have decided this way. So then ultimately, usually the parties settle and never retry it. Okay? So there was not a retrial. We don't know what would have happened in court. It settled after the Allison won the appeal. So the appellate court vacated the judgment and remanded to decide the rescission claim and to decide if there was fraud. And what that appellate court's opinion said was these statements about the law and how it applies to you. Caveat emptor protects certain parties from claims based upon non-disclosure of readily discoverable defects and declares that reliance on certain misrepresentation by such persons to be unreasonable as a matter of law. Okay? So, what that just said is that buyer beware, okay, caveat emptor, protects certain parties from claims based on non-disclosure of readily discoverable defects. So if you fail to put a readily discoverable defect in your disclosure form, but it was discoverable by a reasonable person, that is what caveat emptor is supposed to help you with. So if you omit something that was easily inspected, you're not going to be liable for fraud. Okay? So it also goes on to say, however, the rule doesn't apply to non-disclosure or misrepresentation by all parties, and that a special relationship does exist between a realtor and her clients, in particular a fiduciary one. So what they're also saying, though, is that you have an additional duty that if you have a client, you cannot just rely on caveat emptor. You should be telling your client what you know. Here, they also go on to say, like other professionals, a realtor is held to a higher standard of competency and fairness than is a lay member of the public in the marketplace. I kind of mentioned that to you earlier. Included among your fiduciary duties, a realtor is required to fully disclose facts known to him that are material to the transaction. And because of the affirmative obligations arising from that fiduciary relationship between a realtor and his clients, the defense of caveat emptor by the realtor does not apply when that agent failed to disclose facts known by him that are material. So in this case, Kaufman was liable to his client, the buyer, Allison, because his defense at court was caveat emptor. I didn't need to tell him all these things, but you were the agent, you should have told him what you knew. And so...
Wait a minute, which would trump which?
This court is saying that your duty to a buyer would trump any sort of dual agency. You're not supposed to advocate for one part or the other. Either way, you're supposed to disclose what you know, which they don't get into, but based on other points of law and other cases, that puts you at risk when you are a dual agent, because you might have to disclose something that a seller wouldn't want you to disclose. I mean, and that would eliminate much of those potential risks. Now, you still have a duty. If you know about a latent defect, you have a duty to disclose that. And you've got to tell the seller, you've got to disclose that, or I can't be your agent either. I can't list this property, and I can't go forward with this and take a commission, because I know there was, a foundational crack or, some sort of problem that you covered up with drywall, that sort of thing. And that's going to lead us to our third case, which is Hubbard V Tnt. Let me check our time. Okay, are we good with that? Okay, so Hubbard V Tnt. This says that the real property disclosure form is designed to permit the seller to disclose material matters relating to the physical condition of the property to be transferred. I just want to make sure I had a fax after this. All right, so basically that any material defects in the property that are within the actual knowledge of the seller are supposed to be disclosed, and that a duty of good faith is imposed upon the seller. But liability for non-disclosure does not apply to matters not within their actual knowledge. And that's what was at dispute here, what was within the actual knowledge. So it goes on to say in this case that a seller's response or non-response to the questions posed by the form does not provide a warranty as to the condition of the property. So again, a disclosure form's facts on its face, whatever it says, is not a basis for suing someone because it didn't turn out to be that way. It's not a warranty, okay? It's only a statement of knowledge that potentially could be used if you wanted to sue them for fraud, okay? Fraudulent non-disclosure. So they constitute a representation concerning actual knowledge of the condition of the property in respect to only the particulars specified. In this case, also originating as far back as 1994, Hoover bought the property and conveyed it to her LLC, TNT. So TNT is the name of the company, and that was in 2000. Shanks is the last name of the agent. I actually know her. She's a good agent. She's a broker and has a very good little brokerage. And TNT, okay, and the Marions were her clients. The Marions were a buyer who made an offer to purchase in 2006, and then they found some defects in the home upon inspection. Shanks then drafted an addendum, okay, but Hoover decided to reject that, basically Hoover/TNT. Okay, remember Hoover owns TNT, the LLC. And so she rejected that addendum, and they fell out of contract because she didn't want to fix anything. But after that, okay, while still listing the property, trying to find another buyer, Hoover, the owner of TNT, decided to repair some of those items that had been brought up, right? She figured, well, I might as well improve the property because maybe we're going to have the problem again. So she did some repainting, put some new windows in the turret room, replaced the concrete pad, replaced the garage floor, installed retaining walls in the rear slope of the property, and a few other things that will come up here later. And in 2007, a year later, Hubbard, a new buyer, also uses Shanks to make a $320,000 offer on the property. So Shanks is our dual agent with Hubbard and TNT. So the contract contained an inspection addendum allowing Hubbard to get an inspection, but Hubbard did not. He chose not to get an inspection. After he bought the property, he noticed settling problems. The deck shifted, the sidewalk cracked, and the yard even developed a crack. Again, this is a lakefront property. Hubbard hired an engineer who determined the land was settling and the soil shifting down towards the rear slope towards the lake. And in 2009, 2 years later, Hubbard sued TNT for fraud, negligent misrepresentation, breach of contract, unjust enrichment, and sued Shanks for breach of fiduciary duties, negligence, and promissory estoppel. Testimony at trial from the buyer's expert stated that they believed the defects were concealed by fresh concrete, stucco, wood shims, and would not have been discovered by visual inspection. So they were trying to prove that it was a latent defect that was covered up by these items. The real property disclosure form said that Hoover/TNT had no knowledge of any movement, shifting, deterioration, crack settling, or other problems with the foundation, basement floors, walls, etc. And she wasn't aware of any settling, grading, or erosion problems. What do you think the trial court found? What's that? Anybody want to take a guess?
For the seller?
Okay, for the seller. Anybody else think that it was for the buyer? Okay. All right, so the jury did find for the buyer. All right. So, jury found for the buyer, even though the buyer didn't inspect the property. They found it for the buyer on the breach of contract claim against Hoover for $216,000 in damages. And for Hubbard on the breach of fiduciary duty negligence against Shanks, this was interesting. The jury found the facts were in favor of Hubbard and basically said that Shanks breached her duties, but then they didn't award any damages. They didn't put a monetary assignment on it, probably because they liked Shanks. So after a hearing on punitive damages and attorney's fees, they ended up awarding $68,000 for punitive, which is like punishment, and then $68,000 for attorney's fees. So naturally, the realtor and the seller appealed. What do you think happened on appeal? What's that? You think they reversed? Yeah? Interestingly enough, they did not. They affirmed the trial court's holdings against Hoover, okay, and said that Hoover more or less did commit fraud by not disclosing the stuff that she repaired. And I put repaired in air quotes because more or less that was the factual dispute in the case. All right, so what we have here is a situation where a buyer hired an unlicensed inspector to do an inspection. They found some things wrong. They provided a copy of the report and said, we don't like this. We want you to fix it in order for us to purchase. The seller said, no, I'm not going to do that. But then later of her own accord decided to go ahead and start making the property look better, right? And so what really this is boiling down to is that the repairs were not true repairs. That the experts, the battle of experts at trial was that it was superficial repairs, that they covered up the actual defects so that an inspector could not tell that there were cracks, that there might be problems. And so these cosmetic repairs basically were the seller's downfall. Because basically what they said is that the seller concealed the defects. All right, and that's what you have to be careful about. But the irony here is that the appellate court remanded it to trial court to determine damages against Shanks. And just like the other case, it didn't actually go to a second trial. They settled. The realtor must have paid something and moved on with their lives. But what I think is unfair about this is that somehow Shanks was found to have breached her fiduciary duty because she didn't tell the buyer that there were defects. And it's consistent with that other case, right? You know, should have advised the buyer and all that kind of stuff. But what's interesting about this one is that I couldn't tell from reading it that there was any reason that the realtor should have known that they were only cosmetic defects, because the seller had their own repairs done. And if the realtor thought that they were done correctly, how would you be liable for that? So there's really kind of a problem with this case, and that question was left unanswered. Is the realtor is not an engineer, is not a construction expert. How would you guys know if your client's repairs on their house was sufficient or would be ever considered cosmetic after a bunch of experts have testimony at trial? You wouldn't. So I really think it's an unfair decision against a real estate agent, but it's out there. It's a case. It's in Ohio. It exists. It's a part of our case law. And so you have to be careful, okay, when you're in those situations. If you've got a client that, you know, there was some sort of problem that they went ahead and fixed, you might want to have something from the person doing the fixing that assured that they actually did something. There might be some requirement of you to verify that, or else you're going to have to tell the other side, if you're a dual agent, you're going to have to tell them, well, this is what was found, this is what was in the inspection report, here you go. Because generally you don't have to do that. But this case sort of makes you think that you might have to. Yes, question?
Don't you think, though, that the problem in this case came about because there was the prior property inspection, and that prior property inspection was never shown to the second buyer?
Yes.
And the real estate agent has a duty to say to the seller, there's a prior inspection of the property, and even though this guy can get his own inspection, you ought to disclose that.
Yeah, no, you don't have to. Actually, and yeah. This is the dual agency problem, and the court didn't even address it. But it's a great point, is there was an inspection. Do you have a duty to tell a future buyer about a previous potential buyer's problems? And the answer to that, generally speaking, is no, you don't. But Shanks was a dual agent. So the court was saying that you represented the buyer and you had knowledge of a potential latent defect. You should have disclosed that potential latent defect. And my issue is more with, they were basically saying the realtor should have been an expert enough to know that it was a latent defect. And so I see your point, though. In that situation, because it was questionable, because there was an inspection report previously, and because the realtor had a duty to the buyer, she should have, and in this court's opinion, would have avoided that. Now, you could have those exact same facts in a different county and get a different result. You know what I mean? That's just how the legal system works. But it is something you got to be careful. So in general, if you're only representing a seller, you don't have a duty to provide a copy of a previous inspection report to a future buyer. Okay? But if you are a dual agent, you probably do. We got a couple questions. Yes?
Why has that happened? A couple weeks ago, a broker told me my buyer is asking for the old inspection, so therefore you have to show it to us. Well, we showed it to them, but we have to show it to them?
I am unaware of a legal duty requiring you to do so. But if your broker tells you that's what you should do, then you need to obey your broker. Yeah. Well, no, they can't make you produce something because, again, what is that? They don't have privity to even have access to that. And the question would be, is that somehow concealing a latent defect? Probably not, because if their inspector found it, right, then it's open and obvious for inspection. So you get your own inspector and go figure it out. Courts have routinely held that that's the way that the system works. Yes.
What was the time frame on all this?
What do you mean? As far as how long?
Yeah.
Well, it was 2006 to 2007, so it was
it was just 1
it was a year. Yeah.
Oh, okay.
Yeah.
Are you seeing a trend in Ohio courts not to enforce caveat emptor and the rule in favor of disclose?
That's a good question. So the question is there a trend away from caveat emptor towards disclosure?
And also, dovetail with that, are you seeing, isn't it true, I'm in commercial real estate, isn't it true that it's much more caveat emptor in commercial real estate?
Yes. Yes, and the question is about caveat emptor, and are there decisions that are kind of steering away towards protecting buyers? I can't say that for certain.
Not away from protecting buyers towards protecting.
Yes, yeah, I'm sorry if I misspoke, but yeah, towards, instead of saying buyer beware, but we're gonna try and help you and coddle you a little bit because you're uneducated, right? And you don't know any better. Well, I can't say I have recognized that trend or anything, but I would say our society, especially with things like the CFPB and TRID and the purpose of all of that, society in the United States certainly is going more towards that, woe is a buyer and they don't know anything, and we should really help out a consumer because how could they understand all of this stuff? Whereas in commercial, okay, it's a business person, it's their business to know that. So courts historically don't hold businesses to that same level, that they would, they hold the businesses to a higher level than they would a consumer. Okay, so you're right in that sense. But I just think that society has changed a little bit. I don't research case law all day, so I can't really say what's happening everywhere. But question in the back?
Yeah.
Okay. All right.